In this video, we're going to be learning more about the courts. What is the process when petitioning to determine disability and the appointment of a guardian? And today we have Judge Jennifer Leibson, the Jefferson County District Judge, as our guest. She's been working in the area of guardianship for more than 18 years. Judge Leibson, can you tell us a bit about your work here in the field of guardianship, and then explain what we might expect if we need to petition for guardianship?
Certainly, and thank you for having me, Ms. Smith. I started in 2003 as an assistant county attorney in the guardianship division in Jefferson County. Most recently, I spent 2 years in the guardianship division as a judge. So that was interesting to have the other side of it. And I've always had a special place in my heart for guardianship. I am a founding member of the Kentucky Guardianship Association. So I'm pleased to be here today. And the first thing that a person would do if they're filing for guardianship on someone, if they have considered all of the alternatives to guardianship, AOC 740 is the petition to determine if disabled. And this is what you would come forward, you would fill this out and bring this to your clerk's office to file it. And this is the one that lets the county clerk's office know, okay, I've got a case that I want to bring. So that's the first step, is the filing of the petition to determine if disabled. Once this petition is filed, the first thing that happens is it is reviewed by assistant county attorney, and they're going to verify that all those other options have been tried and have failed before they accept this petition. Mm-hmm. So guardianship is absolutely a last resort, and we don't want anybody to think, oh, I have to do this, especially if you've already got a power of attorney or healthcare surrogate.
Can you define disability? Because if a person is in a coma, or if a person is physically disabled or unable to move about, okay, would that be included?
Disability in terms of guardianship is talking about mental disability only. It is not physical disability. Someone who is in a coma may very well qualify. Someone who has a brain injury, dementia or Alzheimer's, or children who are born with developmental disabilities. So the next part of the packet that you would fill out is the application for appointment of fiduciary of a disabled person. And this is Form AOC 745. Now, occasionally, someone might file a petition for saying this person needs a guardian, but they don't want to be the guardian themselves. Mm-hmm. So the person who wants to be the guardian needs to fill out this application for appointment of fiduciary. That's by the applicant asking to be appointed as the guardian for the other person, okay? This personal identifier sheet is part of it. This is about the respondent. The respondent is what we call the ward or the client prior to them being found legally disabled, prior to them having a guardian appointed. So that's the legal term for the person who is basically being scrutinized to determine if they do or do not need a guardian. So this form, this is AOC 34. That is by the person, that is about the person who's the respondent. And then one other thing that I want to mention, sometimes the person who's filing the guardianship papers may live out of state. As you said, we're governed by the laws of our states, and each state has different laws on guardianship. Kentucky requires that if, for instance, say you live in Louisville, Kentucky, but I live in Indiana. Mm-hmm. I have to fill out this form. It's called the designation of process agent, which means I'm naming someone who lives in the state of Kentucky as a person who will accept mail on my behalf in case the court mail doesn't get to me. So this is a required form for Jefferson. It might not be required everywhere else, but we do require that. So after these forms are filed with the clerk's office, then the court takes over, and the court does a whole bunch of things. First, the court sets a trial date. By law, that trial date is supposed to happen within 60 days of the filing of the petition. So the petitioner, the person who filled out these forms, will get notice of the trial date. The court also appoints an attorney to represent the respondent throughout this proceeding. And that person will review all of the paperwork that is filed and all the paperwork that comes in after the initial filing. They will speak to their client, who is the respondent. if the person is able to talk and get their opinion on the process and see how they want to represent them. Some attorneys listen to their clients, and if they want to fight the issue of guardianship, they will fight the issue in court. Some people and some respondents even agree that they could use the help of a guardian, and so sometimes there is no fight. It really just depends on a case-by-case basis. So the court, in addition to setting a trial date, the court also appoints an attorney to represent the respondent. The court appoints a team of 3 professionals in every single case, and the job of those 3 professionals is to interview the respondent at least once, sometimes they do it more than once, and to make a recommendation to the court about whether or not that person needs a legal guardian to manage their affairs for them. The team is made up of a medical doctor, who is usually a psychiatrist, but not always.
But it'll always be a medical
It'll
doctor.
always be, it must, by law, it must be a medical
What about
doctor.
a nurse practitioner?
It is either a medical doctor or a nurse practitioner, a psychologist, and a social worker. So all 3 of those people are court appointed to evaluate the person and write a written report as to whether or not the person needs a legal guardian. If they do, if all 3 of them agree, then we go forward on a trial and we have a trial. If there is a difference amongst the team members, we may have a pretrial hearing to determine how we're going to go forward, whether we're going to go forward on a bench trial, which is a trial with just the judge, or whether we're going to go forward on a trial with a jury. So the team each does a written report. They submit that to the court. One of the 3 team members will testify at the trial, and the jury is there listening if it's a jury trial, or the judge is there listening if it's a bench trial, and they will make a determination based on the testimony of one of those team members as well as the reports of all 3 of them. So all 3 of those reports are entered into the record as evidence, and either the judge or the jury will review all 3 of those reports when they make their decision.
Then we get to the trial.
You get to the trial.
Hear all the facts.
You hear all the facts, you hear the witness testify, you have the 3 reports that are entered into evidence for either the judge or the jury to consider, and then the judge or the jury will make a determination. There are 2 areas that guardianship in Kentucky is divided into. One is personal affairs, and that includes living arrangements, medical decisions, those types of things. The other is financial affairs, and that's pretty self-explanatory. So the judge or the jury can determine that the person is legally disabled in both of those affairs, in one of those affairs but not the other, or they can determine that the person is partially disabled in either of those affairs. Partially disabled means you have a guardian appointed to manage some of those affairs, but not all. For instance, someone may be able to handle their living arrangements, but not their medical affairs. So you would have a limited or partial personal guardian to handle those for you. It's just to make it really confusing.
But in developing the petition or the order of decision, you will clearly note in there any of the limitations.
Absolutely.
On a limited guardian. It will be, show me the paper.
The actual disability judgment specifies what areas a guardian is appointed for. It could be all, or it could be some. And it's specifically marked on the disability judgment which areas the person needs help. And then that order is filed with the county clerk's office. It allegedly puts the world on notice that the person has a guardian. And then after the trial, once the judge or the jury determine what the level of disability is, then we go through the appointing of a guardian. Now, oftentimes, in the vast majority of cases, there is one person who has filed the petition and one person, the same person, who has applied to be the guardian. That is the vast majority of cases. So unless there is something on the person's application that is a red flag, that person is almost always appointed. Occasionally, you will have more than one person applying to be the guardian, and when that is the case, there is a hearing after the disability judgment is entered to determine who should be the guardian. So that's the case, the applicants will testify and the judge will make a determination who should be the guardian. It is important to understand that even if the disability judgment is done by a jury, it is the judge who decides who should be the guardian, not the jury. The jury would be released at that point, and then the judge would conduct the hearing on appointment of a guardian.
Okay.
So also, just like I said, guardianship is divided up into two categories, personal affairs and financial. It is possible for one person to be the personal guardian and another person or agency to be the financial guardian. So sometimes if the ward has 2 children, one may be a nurse, so that would be the perfect person to be the personal guardian who can handle the medical affairs. And let's say the other one is a CPA, so obviously that person would be the person handling the financial affairs. So it is possible to divide it up that way.
Thank you so much.
Thank you.
I really appreciate your time and
My
energy
pleasure.
and your time on the bench. You've had lots of experience in this, and I think we all certainly appreciate that.
Thank you.
So,
Thank you very much. Pleasure to be here.